All right, let's talk about something we've all done. You're faced with this huge wall of tiny text in a contract. That's the liability clause. Well, today, we're going to pull back the curtain and see how courts actually read that fine print, and more importantly, what it means for you.
I mean, think about it. A new phone, a gym membership, even just a simple software update. Bam, terms and conditions. And what do? We scroll, we tick that little box, and we kind of just hope for the best, right? But have you ever stopped to think, what on earth are we really agreeing to in all that legal jargon?
So deep inside that fine print, companies pack in these things called exclusion or limitation of liability clauses. The goal? It's pretty simple, actually. They want to limit their legal responsibility if something goes wrong. It's like they're trying to build this impenetrable legal fortress to shield themselves from being held accountable.
And that right there, that's what we're calling the fine print trap. It feels totally one-sided, doesn't it? Like you, the consumer, are taking on all the risk. But here's the big question. Is that fine print really as ironclad as those companies want you to think it is? Okay, this is absolutely crucial to get. Courts don't just look at this stuff neutrally. Nope, they often come into it with a healthy dose of skepticism. They see the huge power imbalance, a massive corporation versus just one person. So right from the get-go, they're already looking at these clauses thinking, this could be really unfair.
And that skepticism, it means the legal system can actually be a really powerful ally for you. Because the moment a dispute over that fine print lands in a courtroom, well, the whole game changes. That super carefully crafted legal text, it gets put under a massive microscope.
So check out this contrast. The company, right? They want their clause to be this giant catch-all shield. They use the vaguest, broadest language they can to cover literally everything. But the court? It does the complete opposite. It reads that exact same clause as narrowly as it possibly can, almost like it's hunting for any little bit of ambiguity or vagueness. See, the court's number one job isn't just to blindly uphold the contract, it's to make sure the outcome is fair.
So how do the courts actually do this? How do they make sure things are fair? Well, it's not just a gut feeling. They have very specific legal tools and principles they can use. Think of it as a powerful legal shield, designed specifically to protect you, the consumer.
Okay, let's break down 3 of the most powerful of these protections. These are fundamental ideas in the law that really limit what a company can get away with in its fine print.
First up, we have something you can think of as unbreakable guarantees. Lots of legal systems have them, and a great example is the Australian consumer law. What it says is that companies absolutely cannot use a contract to weasel out of their most basic obligations. Like making sure a product actually works and is of decent quality. Any clause that even tries to do that, it's just void, gone. It's a total non-negotiable.
Second, and listen, this one is huge. A company cannot use a contract to get out of being truthful. Let me say that again. If a business misleads you or deceives you to get you to sign on the dotted line, they can't then turn around and point to some clause in that very same contract to protect themselves. The law is really clear here. Your right to be treated honestly can't just be signed away in some fine print.
And finally, there's the ambiguity rule. Now, in legal circles, it has a fancy Latin name, contra proferentem. But the idea behind it is super simple and really powerful. If a clause is written poorly, if it's unclear and could be read in more than one way, the court will always choose the meaning that works against the side that wrote the contract. This puts all the pressure, the entire burden on the company to be crystal clear, no excuses.
And just so you know, this isn't some brand new idea. It's a principle that's been around for a long time, locked into place by major court cases like Darlington Futures. It's what forces companies to be precise. If they decide to be vague or confusing in their contracts, well, they're doing it at their own risk. Okay, so we've got these powerful legal principles, right? But what does this actually look like in the real world? How does it all come together to protect an actual person? Well, a perfect example is a case that involved a fitness center. A new member signs up, something goes wrong, and of course, the gym points to this really broad liability clause in their contract. So the court had to step in and decide, was that fine print actually fair? Was it even enforceable? And the way the court handled it shows everything we've been talking about. So, step 1. The company, the gym, writes this super broad clause trying to get out of everything. Step 2. The consumer gets hurt. But then step 3. The court doesn't just take the company's word for it. It examines that clause incredibly strictly. And finally, step 4. It reads the clause narrowly in a way that favors the consumer and decides, nope, this clause doesn't actually cover this specific situation. That is judicial skepticism in action right there. So now that we've seen how courts can literally dismantle these clauses piece by piece, what's the big takeaway?
It's realizing that the power dynamic, it is not nearly as one-sided as it looks when you're just staring at that contract.
All right, let's do a quick recap of the key points to remember. First, courts are naturally skeptical of fine print that tries to limit your rights. Second, you have key laws that give you unbreakable guarantees. Third, any ambiguity, any unclear language in a contract, it's going to be used against the company who wrote it. And maybe the most important of all, you cannot be forced to sign away your right to be treated truthfully.
Look, the legal system gives you this incredible safety net, a real shield to protect you from unfair terms. But going to court is the last resort, you know? It's not the first move. So that begs the question, what's your first line of defense, long before any lawyers get involved?
It's your awareness. That's it. Just knowing that these clauses aren't invincible, knowing that they're going to be scrutinized, and knowing that you have fundamental rights. That is your most powerful tool. It completely changes how you look at every contract you sign. And that is a power that no amount of fine print can ever take away from you.